Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello beautiful people, welcome back to our channel. Right now, Dele Farotimi's case is a little more complicated than we thought, as more rejoiners are coming in. And of course, you could recollect that some few days back, Peter Obi decided to wade into the matter by visiting Afe Babalola. Of course, he has decided to give his response to Peter Obi openly. Remember, it was a closed-door meeting, but openly he had said to say the only condition, should I say two conditions, through which he will let Farontimi free. You're going to find out what it is. And of course, other people have said to join themselves into this case. Tell you that Nigerians are following up very closely. Don't get deceived by the online presence. There is strong offline presence to this case. But before we go into newspaper, kindly subscribe to our channel. And according to the news, the legal luminary Afe Babalola has told the 2023 Labour Party presidential candidate Peter Obi what to do. And according to the news, Babalola revealed this when he was visited by the former Anambra governor some few days back. Obi reportedly went to talk to Babalola for forgiveness on behalf of Dele Farotimi, a prominent member of the obedient movement. It was gathered that before Obi's visit, former President Olusegun Obasanjo and Catholic Bishop of Sokoto Diocese Matthew Hassan Kuka had reached out to Chief Babalola on the issue. Farotimi has been on detention in Ado-Ekiti since last week over charges of criminal defamation and cybercrime. He was accused by Babalola of tarnishing his hard-earned reputation in the book titled Nigeria and Its Criminal Justice System. Babalola stated that if Farotimi admits, that's the condition now, if Farotimi admits to the allegations and issues an apology, he would consider dropping the case. Afe told Obi that he, Babalola, has nothing to gain by Farotimi's incarceration. If he says the allegations are false and offers apology in some newspapers, then the case can be withdrawn, a source said. Another source said that after Peter Obi made his case for Farotimi, Babalola asked whether he had seen Farotimi, that he had come to appeal on his behalf, to know whether he has been remorseful. Baba told Obi that everything depended on whether Farotimi was remorseful for his actions or not. Another source added that Farotimi, who reportedly told Obi that he did not invite anybody to plead on his behalf, demanded that the case against him be withdrawn first as precondition for his apology. Farotimi will remain in prison custody till December 20th, when Magistrate Adeosun will rule on his bail application. But let's find out those who are now rejoiners to this matter. Human rights organization, the Civil Rights Realization and Advancement Network, CRRAN, has condemned the arrest, detention, and remand of Dele Farotimi, Esquire, describing it as unconstitutional and one which violates the rule of law. While demanding the immediate release of Farotimi, the group, in a statement some few hours ago by its president, Olu Omotayo, lamented that the hard-earned constitutional guaranteed rights of citizens are gradually being filtered away by the court, and this calls for urgent attention. CRRAN appealed to the Chief Justice of Nigeria to urgently save the citizens from the dangerous routes the courts in Nigeria are applying. The organization emphasized that the court had continued to act as an appendage of the Nigerian police, a development it warned would spell doom for human rights and democracy in the country. The group observed that as economy continues to worsen in the country, so also the observance of the rule of law and respect for human rights of the citizens continue to worsen, as courts in the country now operate as appendage or extension of the Nigerian police. We just heard in the news that Dele Farontimi, Esquire, after his abduction in Lagos, was arraigned in court today in Ekiti State and remanded in prison. Farotimi was alleged to have made defamatory remarks against Afe Babalola in his recent publication. In the famous author Nwaknkwo's case, the Court of Appeal held that sedition or criminal defamation was a law used by our colonial masters to subjugate the locals, and there should be nothing like criminal defamation in a democratic setup, as there are enough redress available for government or aggrieved citizens under the law of libel. The group, however, regretted that since over a year ago President Bola Tinubu took over leadership of Nigeria, the number of citizens arrested and detained for criminal defamation has surpassed what happened in any of the previous democratic governments in Nigeria. According to the group, in the case of Afe Nwaknkwo versus the state 1985, 6 NCALR 228, Nwaknkwo, who was a gubernatorial candidate in Anambra State in 1982, was alleged to have attacked the governor, Jim Nwobodo, in a book he published titled How Jim Nwobodo Rules Anambra State. He was sentenced to 12 months imprisonment for the offenses of publishing seditious publication and distributing seditious publications. He went on appeal. The Court of Appeal discharged and acquitted him and held inter alia that although the book sharply criticized the government, it was indeed healthy in a true democracy. In the ruling delivered by Honorable Justice Belgore, the Court of Appeal Court held that the charge against the appellant or accused was inconsistent with the Section 36 and 41 of the then 1979 Constitution. CRRAN described the current development as surprising that over 40 years after the court judgment, which is available for judges and magistrates to read, our society and development is being dragged back to give effect to what was condemned by the judiciary over 40 years ago. We urge the Chief Justice of Nigeria to urgently save the citizens from dangerous route the court in Nigeria is plying. The hard-earned constitutional guaranteed rights of citizens are gradually being filtered away by the courts, and this calls for urgent attention. We condemn the arrest, detention, and remand of Farotimi Esquire, as it is unconstitutional and violates the rule of law. Those are the words of CRRAN. Little wonder that such a case has existed and they were discharged. Nwaknkwo was discharged and acquitted. Similar situation, similar scenario, and he worked as a free man 40 years ago. And now similar situation is coming, and it looks as if it was never in our judiciary system. This is really worrisome. I think there's a lot of hackling tax right in front of Ikekere, the CGN. How she will maneuver this is whether the judiciary and Nigeria come out of this stronger is really up to how this matter will be handled. That's where we're going to wrap it up. Let's meet it up.